Appeal Part Head in the matter of BT Group PLC and Royal Mail Group Ltd and DAF Trucks Limited and others.
Yes.
Good morning, my lords. I'm going to be addressing ground 4 of the appeal on behalf of Royal Mail. At the outset of his submissions on Tuesday, Mr. Beard described ground 4 as important. We agree, not because it raises any issue of wider significance, but because it concerns the cumulative impact on Royal Mail of being unlawfully deprived of the overcharge for a very long time indeed. The relevant finance period runs from 1997 until 2022. Its importance is reflected in the thoroughness with which Royal Mail advanced its claim for compound interest at trial and the care with which the tribunal addressed it in the judgment. By way of illustration, Royal Mail's claim for financing losses was the subject of 2 factual witness statements from Royal Mail, a total of 6 expert reports from the financing experts, a joint expert statement, some 2 days of factual and expert cross-examination, and extensive documentary evidence.
Just to put some flesh on the bones, how much money is at stake here?
The value of the
difference between whether you're right and wrong, if you see.
Well, the value of the award of compound interest, I think, is 19 million.
19.
And I think the final order is in the core bundle.
Yeah.
What I don't know is what the value of the alternative approach to weighting would have been on the tribunal's overcharge. Yeah.
Okay.
So the tribunal evaluated the claim carefully, reviewing the authorities on compound interest, weighing up the expert and factual evidence, and explaining its reasoning over some 20 pages of the judgment. Ultimately, it rejected Royal Mail's claim for compound interest based on the WACC, but granted its claim based on the alternative measure. And the alternative measure was a combination of Royal Mail's cost of debt and the foregone interest on its short-term investments over the relevant period. This measure was agreed in principle by DAF and their expert, Mr. Delamere, and only 2 matters as regards this measure were in dispute. Firstly, whether certain debt instruments should be included in the calculation. The tribunal held that they should be, and DAF has not challenged that decision. Secondly, how Royal Mail's cost of debt and return on short-term investments should be combined into a single interest rate by which to calculate Royal Mail's financing losses. This was referred to as the appropriate weighting issue. And it is the tribunal's decision on weighting that DAF challenges on appeal. In other words, its decision to accept the approach to weighting advanced by Royal Mail's expert, Mr. Earwaker. So the scope of the appeal is relatively narrow. Now, identifying the appropriate weighting required the tribunal to draw inferences from the evidence as to what Royal Mail would have done in the counterfactual with the money it used to pay the unlawful overcharge. This was quintessentially a matter of evaluative judgment for the tribunal, based on its view of the expert evidence and the extensive factual material that underpinned it. The question for this court is whether the tribunal made an error in reaching that judgment, and that is a matter to which the normal principles of appellate restraint apply. Now, recognising the formidable challenge posed by those principles, DAF is driven to adopt an extreme position. It contends that there was no factual evidence to support the approach to weighting the tribunal adopted. But that argument is both inherently unlikely and demonstrably incorrect, as I will show. I propose to develop my submissions in 3 parts. Firstly, the nature of the tribunal's task. Secondly, the tribunal's assessment as regards weighting. And thirdly, the factual evidence to support the tribunal's approach. So part 1, the nature of the tribunal's task. If we could turn, please, to the judgment in bundle C, tab 17, page 424. You'll see at the top of page 424, paragraph 767, where the tribunal is dealing with the ample evidence before the court to support the claim for compound interest. And it's really the end of this paragraph that I wish to draw your attention to. As was said in Cat Sainsbury's, the court or tribunal draws broad axe inferences as to what the claimant would have done in the counterfactual with the money it had to use to pay the overcharge. So that's how the tribunal saw its task. And of course, by looking at the counterfactual in this way, one can estimate the losses that Royal Mail suffered as a result of being deprived of that money. And the tribunal's approach was entirely consistent with the authorities. And if you have the previous page of the tribunal's judgment, page 423, you'll see the quotes set out from Sempra. And paragraph 95 of Sempra, Lord Nichols' judgment, Mr. Beard took you to yesterday, but he rather skipped over the second part of that paragraph, which I do wish to draw your attention to. And this is the final three sentences. Whatever form the loss takes, the court will, here as elsewhere, draw from the proved or admitted facts such inferences as are appropriate. That is a matter for the trial judge. There are no special rules for the proof of facts in this area of the law. And Sagicor, to which Mr. Beard also took you, is to similar effect. And what Sagicor also makes plain is that the law does not require a detailed examination of a plaintiff's financial affairs. For your note, that is paragraph 33 of Sagicor, which is at Authorities 4, tab 30, page 1636. So the law takes a pragmatic approach to the evidence required to prove a claim for interest as damages. And this reflects in my submission the fact that a claimant will often be unable to say precisely what it would have done differently if the withheld money had been available to it. And the nature of the tribunal's task in this case is important because the drawing of inferences as regards the counterfactual is an inherently uncertain exercise, just like the assessment of overcharge. It involves evaluative judgments which the tribunal is uniquely well placed to make. And the nature of the tribunal's task is also important because of the two expert approaches before it. Only Mr. Earwaker's made any serious attempt to draw inferences from the evidence. Turning then to part 2 of my submission, the tribunal's assessment, we could turn please to, hopefully you still have the judgment open, tab 17 of bundle C. We could turn please to page 432. Paragraph 798. You see there that the tribunal explains that having rejected the WACC, it now turns to the alternative measure, which is agreed to be appropriate in principle by DAF and Mr. Dahmer. Explains what it involves. This is broadly what happened in Cat Sainsbury's and involves assumptions as to how Royal Mail would have used the additional funds that it would have had in the absence of the overcharge. And then it sets out a quote from Mr. Delamer's evidence. But for an overcharge, the claimant would have had additional funds. These funds could have been used to increase the actual investments in short-term investments, generating additional returns to those it actually generated, or to reduce the amounts of debt the claimant has actually held in the past, hence reducing the amounts of interest it has actually paid on such debt. As such, the potential relevance of short-term investments and debt when estimating the financing costs the claimants could have avoided in the counterfactual scenario is self-evident to me. And then you see at 799, not only was the above approach agreed between the experts, they also managed to agree estimates of the returns made by Royal Mail on short-term investments over the entirety of the relevant period and Royal Mail's cost of debt from 1997 until 2012-2013. So DAF and Mr. Delamer agreed that the alternative measure was appropriate in principle. Mr. Delamer positively endorsed it. And the experts also agreed the majority of the inputs for that measure. And of course, the reason they were able to agree those inputs was because those matters were the subject of factual evidence. Then just moving on through the judgment, we don't need to look at what the tribunal said about the cost of debt. It resolved it in Royal Mail's favour. And then it turned to weighting on page 437. And one sees the subheading at the bottom of 437. And just for context, this issue was addressed in Mr. Delamer's first and third reports and Mr. Earwaker's second and third reports, and also in the joint expert statement. So it was the subject of quite extensive analysis. Paragraph 819, the tribunal identifies the area of disagreement concerning how Royal Mail's cost of debt and return on short-term investments should be combined into a single figure. And then it explains Mr. Earwaker's approach, which the court will understand following Mr. Beard's submissions yesterday. And then at 820 and 821, the tribunal carefully lays out the rationale for Mr. Earwaker's approach. And I'm going to come on to Mr. Earwaker's report, so I won't dwell on what the tribunal says about it, but it's certainly worth taking the time to read paragraph 820 and 821 in full. And then moving over the page, paragraph 822, the tribunal describes Mr. Delama's approach, and one sees at the end of 822, Mr. Beard, KC, said that it had the merit, this is Mr. Delama's approach, the merit of not speculating what Royal Mail would have done with the extra funds in the counterfactual, particularly where Royal Mail's evidence had not addressed that point. And we, of course, said that actually that wasn't a merit, it wasn't a benefit in Mr. Delama's approach, it was a weakness. And our submissions on that are recorded at 823. And then the tribunal's conclusion at 824 is obviously key. We prefer Mr. Earwaker's approach, which is based on how a rational business such as Royal Mail would have used extra funds that it had at the relevant time. His two-period characterisation of Royal Mail's financial position as a net investor in the first period and a net borrower in the second is credible on the evidence, and it would therefore be more likely that Royal Mail would use the funds in one direction rather than two. That, therefore, is a reasonable way to assess Royal Mail's actual cost of financing the overcharge. So, faced with two expert approaches on weighting, the tribunal opted for Mr. Earwaker's, which it thought reflected how a rational business would operate. And it bears emphasis that the tribunal didn't simply assume that Mr. Earwaker's approach was factually sound. It specifically considered the point and satisfied itself that there was a credible factual underpinning. Now, of course, the question for this court is not whether Mr. Delama's or any other approach to weighting would have been preferable. It is whether in reaching its conclusion the tribunal committed an identifiable error. And DAF's central...
In this instance, by reaching a conclusion for which there was no evidential support.
Indeed.
And that's the only basis on which it said there was an error.
That is DAF's...
No error of law as such.
No, that is certainly DAF's central case, namely to say that there was no factual evidence at all to support Mr. Earwaker's approach. DAF also contends that the tribunal's approach was clearly irrational, which we've dealt with in our skeleton argument.
That's all part and parcel of the same point.
It all comes together.
Because if there was evidence to support the approach, by definition, the tribunal's approach can't have been irrational.
Well, that's certainly our submission, yes. I turn then to the third part of my submissions, which is the factual evidence that there was to support Mr. Earwaker's approach. And for this, can we turn, please, to Mr. Earwaker's second report, which is in a supplementary bundle, tab 15. The relevant section begins on page 189. And one sees the heading 4D, proportions of short-term investments and debt. So this is the weighting issue. And Mr. Earwaker explains that Mr. Delama considers only briefly the relative weights that the tribunal should place. And he sets out the two alternatives that Mr. Delama addressed. One was a simple 50-50 weighting, and then the second, a set of weights based on the relative size of Royal Mail's short-term investments and outstanding debt in each 12-month period. And then Mr. Earwaker says, I consider that it's possible to improve the accuracy of this kind of computation substantially. I note in particular that the scale of Royal Mail's short-term investments and the scale of Royal Mail's borrowings have changed materially over time. And then he sets out the relevant data at table 6. And then at 4.24, Mr. Earwaker explains, the table shows that prior to 2007, Royal Mail typically maintained short-term investments worth at least 1 billion. This was a function of the cash surpluses that the company was able to generate during a period when its business was profitable. These short-term investments then shrank considerably during 2007 as the postal operations faced increasing financial challenges. From 2008 onwards, Royal Mail took on additional borrowing to finance its UK operations as its previously profitable business started to record losses. My understanding, based on the explanation given by Mr. Jevons, is that the amounts shown in the middle column of the table from this point onwards represent a basic level of working capital that the Royal Mail directors judged they needed to maintain access to at short notice, rather than the kinds of surpluses of excess cash seen in the period 1997 to 2007. And then at 4.26, in my opinion, in circumstances depicted in Table 6, the rate of interest on short-term investments has greater relevance prior to 2008, and the rate of interest on debt has greater relevance from 2008 onwards. If I think about the impact that defendants overcharging had, it seems to me that it is logical, given Royal Mail's overall financial position, to surmise that, and then he sets out his approach, the pre and post 2008 distinction. And so what one sees immediately is that Mr. Earwaker's approach was firmly rooted in factual evidence as to the scale and evolution of Royal Mail's debt and short-term investments over the relevant period. The data set out in Table 6 showed a contrast between the two periods. The earlier period when Royal Mail held significant cash and limited debt, and the later period when that general trend was reversed. And that was why Mr. Earwaker took the approach he did.
Yeah.
He also drew on Mr. Jevons' witness evidence to help understand the data. You see that at 4.25. But it bears emphasis that this wasn't the only factual evidence that Mr. Earwaker and Mr. Delaware had access to. The experts were provided with extensive factual material concerning Royal Mail's finances, and this included its accounts and annual reports for each year of the relevant period. And there are examples in the supplementary bundle at tabs 5, 6 and 11. And it also included the individual debt instruments entered into by Royal Mail. Some of those are referred to in the Tribunal's reasoning on cost of debt, paragraph 801 onwards. And that was why, that wider body of evidence, that was why Mr. Earwaker was able to make those observations in 4.24, that the postal business was profitable pre-2008, and in 4.25, that it, from 2008 onwards, took on additional borrowing to finance its UK operations as it started to record losses. And that wider body of evidence is also why the experts were able to calculate not only the scale of short-term investments and debt, but the rates of interest paid by and to Royal Mail. And one sees those rates at Table 7 of this second report from Mr. Earwaker. Now, Mr. Beard submitted yesterday that all companies will be net investors or net debtors. But in my submission, that ignores the fact that Mr. Earwaker justified his approach by reference to Royal Mail's specific circumstances. If I could just elaborate on that. Pre-2008, one can see in Table 6 that there is some debt. And Mr. Beard relied on this in challenging the Tribunal's acceptance of the approach for the pre-2008 period. But as my Lord Justice Green pointed out yesterday, Royal Mail typically borrowed in this period only to finance overseas acquisitions, not to fund Royal Mail's UK operations. And just to show you where that comes up, if one turns to the joint expert statement, which is in the supplementary bundle at tab 20, page 274, one sees at the top of the table Mr. Earwaker's position, third column from the left. Prior to 2008, Royal Mail held significant amounts of surplus cash and borrowed only to finance international acquisitions. can show the court the factual underpinning for that, if it would be helpful. But Mr. Earwaker was not challenged on that at trial, and indeed we don't understand DAF to be challenging it on appeal. So, unless the court wishes me to show it factual
Well, unless
underpinning
it's challenged now, and Mr. Baird hasn't stood up and said it was challenged, then we take it as read that that's based upon an underlying evidential material.
But Mr. Earwaker certainly made those assertions. We said they're not relevant for this purpose, so.
well, out of abundance of caution.
Well, the question for the court is whether there was material evidence upon which Mr. Earwaker's approach could be justified. And this is an example of exactly that, because you're making the point that's being made here is that during the period prior to 2008, Royal Mail didn't borrow, save to fund overseas investments.
Yes.
And presumably borrowed enough to fund the overseas investments which it had. So if one's asking oneself the question, what would it have done with a whole load of additional cash? It wouldn't have used it to fund the overseas investments, because that was already covered.
Indeed,
This is the point. Isn't it?
exactly the point. There's no reason to think that the debt that was held in the pre-2008 period would have been lower in the counterfactual without the overcharge, because that debt was held for an entirely different purpose.
Yeah.
May I just briefly show you where this point is made good? It's in Mr. Earwaker's second report, which we were just looking at.
Yeah.
In tab 15. And it's on page 187.
187.
187.
Yeah.
And you see table 4 there, which is a table of Royal Mail's borrowing. And you'll see that the first 3 rows, which are agreed between the experts, the first 3 rows deal with the pre-2008 position. So the first row, 1998-99, the Post Office Corporation borrowed around £100 million to finance the acquisition of a German parcel company. And then the second row, 2000-2001, Royal Mail took on £500 million of debt via a borrowing facility provided by the Secretary of State, the GLS facility. And I need to take you to another tab just to show you where it's explained that that was for an overseas acquisition. And it's in S3, which is a commissioned state aid decision dealing with a complaint by Deutsche Post.
S3.
S3. And if one looks at page 10,
Oh, this is a state aid point, is it?
yes,
Because they borrowed the money from the Secretary of State.
yes, exactly.
Okay.
But one sees at recital 19 at the bottom of page 10 on the right-hand side, the 2001 loan, which is one we were just looking at in the table. In February 2001, the UK authorities made a loan of £500 million to Royal Mail to finance overseas acquisitions for the mail and parcels business. And then there's a bit more detail on page 11 at recital 48.
Yeah.
So that,
Does that cover the third column down as well?
the third row,
Yes, both the ones 2000 and 2001, then there's the 102 and 2 and 3.
no, I don't think it does, but I'm going to tell you what our position is on the third row. The third row is the mail facilities, and you'll see the table says Royal Mail entered into a credit facilities agreement with the Secretary of State, which provided Royal Mail with access to additional debt finance the mail facilities if and when it needed it. And then you see 2 rows down.
Sorry, where are we looking at? Which rows are we looking at?
Sorry, I'm back in table 4.
On page 7.
Yeah.
187.
Oh, I've got it, yeah.
So I've dealt with the first two rows,
Yeah,
and the
yeah,
third
got
row
it.
is the final one in the relevant time period. It refers to the mail facilities agreement with the Secretary of
I
State.
see. So that was first exploited in 2009-10.
Exactly,
It was drawn down on then.
precisely,
I see. That's the fifth column down.
yes.
Oh, yes, got it, yes.
And then
So it's only the first two which are really relevant.
it's only the first two that give rise to any debt in the
Yes.
pre-2008
Got it.
period.
Got it.
And if one goes back to page 189 of Earwaker 2, back to table 6, which we've been looking at,
Well, that's demonstrable. If you go back to table 6, isn't it? Because through all the years prior to 8-9, it was at 500.
you see the figures that match.
And then it goes up to 800, and then it goes up to 1.17.
Yeah.
And that corresponds with the table 4, the fifth entry about the drawdowns.
That's right. Exactly. So that's the point on the debt for pre-2008. And then for post-2008, Mr. Beard argued that, well, because Royal Mail still had some short-term investments in this period, the tribunal was wrong to accept the approach for that period. But there are two answers to that. Firstly, the tribunal specifically dealt with that point in the judgment at paragraph 821. And if we could just turn back to that, please. That's C17 438. If you keep the supplementary bundle to hand, I'm going to be coming back to it in a moment. But 821 of the judgment is where the tribunal deals with this. Mr. Earwaker's explanation for why Royal Mail actually held cash reserves in short-term investments at the same time as it was a net borrower of money was that Royal Mail, like many other businesses, needed to have some short-term funds available for liquidity purposes. And that, in my submission, is a perfectly rational answer to DAF's point. That's what the short-term investments, or the funds held in short-term investments, that's what they were for, post-2008. And the second point is that in dealing with that, the tribunal had the benefit of the evidence that Mr. Earwaker gave on this in cross-examination. And I'd like to show it to you, please, because it's illuminating and it's short. And it's in the supplementary bundle at tab 22. Page 288.
Yeah.
Do you have that? And if I could just invite the court, please, to read from line 10 on page 288. This is Mr. Earwaker's oral evidence, through to line 16 on page 289, please.
Okay. This is cross-examination
Cross-examination.
by Mr. Beard.
Yes. So I don't need to put any gloss on Mr. Earwaker's evidence. That was the evidence before the tribunal. And in my submission, it provided a perfectly rational basis for the tribunal's acceptance of Mr. Earwaker's two-period approach. And so just to conclude on this point, in view of the evidence I've referred the court to, including the evidence reflected in Earwaker 2, DAF's argument that there was no factual evidence to support Mr. Earwaker's approach is clearly wrong. There was cogent evidence from Mr. Earwaker drew his inferences. The tribunal found his approach to be credible on the evidence, and it was perfectly entitled to do so. Now, in light of that, DAF falls back onto a somewhat different argument, namely that Royal Mail's witness evidence provides no support for Mr. Earwaker's approach. And it puts this argument in two ways, neither of which has any merit in my submission. Firstly, DAF complains that Mr. Jevons didn't give evidence of a change in approach after 2008. In fact, Mr. Earwaker didn't refer so much to a change of approach, but he identified a change in circumstances as Royal Mail came to face increasing financial challenges. But the fundamental point is that whether or not that change of circumstances or change in approach was addressed by Mr. Jevons, it was reflected in a clear shift in the data from short-term investments to debt. And it bears emphasis that both experts relied primarily on the data to produce what they regarded as appropriate weightings. Mr. Earwaker also relied on other evidence to interpret and draw inferences from the data, and that included Mr. Jevons' witness statement, and it included the various other documents that were before the experts, the annual reports and accounts, the individual debt instruments. That was a perfectly legitimate approach. Now, you'll see Mr. Earwaker referred to section 17 of Mr. Jevons' witness statement at 4.25 of Earwaker 2, and it's also reflected in that the relevant part of the tribunal's judgment. I think it's 821, paragraph 821. I don't need to take you to Mr. Jevons' witness statement, but what he did was he gave a broad overview of Royal Mail's use of cash balances and working capital over the relevant period as a whole. He was dealing with it at a much broader level. But the data and other evidence before the experts provided additional insights and allowed for a more nuanced approach as reflected in Mr. Earwaker's evidence. In my submission, it's a counsel of perfection to suggest there had to be witness evidence to explain the trends in the data. That is not what the law requires. The second point DAF makes is to say that Mr. Jevons didn't give evidence about what Royal Mail would have done with the additional funds in the counterfactual. Such evidence, in my submission, would have been hypothetical and therefore of limited use, as the tribunal observed at paragraph 767. And again, it's not what the law requires. All that is required, as we saw from Sempra, and as one sees from Sagicor, is evidence from which inferences may properly be drawn. And for your note, I don't need to turn it up, but for your note, Sagicor paragraph 37 actually gives some examples of the sort of evidence that may suffice. And you'll see, when you look at them, that's precisely what Royal Mail adduced. So there is nothing in DAF's fallback argument based on Mr. Jevons' witness evidence.
Any indication of what a company might have done 10 or 15 years ago is bound to be speculation.
Precisely.
It's impossible to be precise, even with the benefit of hindsight, as to what the business might have done so long before in entirely different circumstances.
All one can do is draw inferences from the factual evidence we do have. And that factual evidence was ultimately uncontested, the data. I think Mr. Beard accepted yesterday the data was uncontested. So all Mr. Earwaker could do was draw reasonable inferences from that data, and that's what the tribunal did as well. And that was entirely the right approach in my submission. For completeness, and finally, you'll recall that on weighting, the tribunal was invited to choose between two competing expert approaches. And Mr. Delama's approach, in my submission, was inadequate for the reasons recorded in the judgment, paragraph 823. I say recorded in the judgment because the tribunal is recording my submissions. But just to explain briefly, unlike Mr. Earwaker, Mr. Delamere did not attempt to consider how Royal Mail would have acted. Instead, he simply allocated the additional funds to short-term investments and debt in proportions that corresponded precisely to the relative proportions of short-term investments and debt held at any given time. And if I could just show you very quickly what he said about this, what Mr. Delamere said about this in cross-examination, supplementary bundle, tab 22, page 297. Tab 22 of the supplementary bundle, page 297.
Yeah.
And the relevant section begins on line 20, which is the question, my question. If I could just ask the court, please, to read from line 20 over to line 22 on the following page, please. So one sees, particularly at lines 3 to 6 of page 298, have you considered for yourself how you think Royal Mail may have deployed the additional funds it would have had available to it but for the overcharge? No. That, in my submission, was the problem with Mr. Delamere's approach, and that was why we described it as a blunt and oversimplistic approach. So to finish, the tribunal was plainly entitled, in my submission, to prefer Mr. Earwaker's approach to weighting, and DAF has not identified any error on the tribunal's part in doing so. Unless I can assist the court further, those are my submissions.
Shall I, before you put those bundles away, shall I reply on ground 4 first, whilst it's fresh in your minds, and get that out of the way? Because the joys of coming back to it, I know, tantalising, but let's just stick with what Mr. Lask's been looking at. Tab 22 in the supplemental bundle, some of the cross-examination material. Because the key thing here, and you heard it from Mr. Lask today, he kept talking about Mr. Now, I'm going to say Erica because I thought that was how it was pronounced, but if it's Earwaker, it's Earwaker. I'm going back to Earwaker. Mr. Earwaker's accounts, he kept referring to the facts that Mr. Earwaker had found. He's the expert. He's not the witness of fact. And that's the central fallacy here. Mr. Earwaker was going off on a frolic in relation to his assertions. And what he didn't have was a factual basis to do it on the basis of Mr. Jevons' witness evidence. Mr. Jevons, the CFO. And I'll come back to the data in a minute. But we actually tested this. If we pick it up at page 291, because as you saw from the material Mr. Lask took you to and emphasised, Mr. Earwaker said, well, I saw this in Mr. Jevons' statement. So we asked about it. You see that, 291, line 14. So you've got this detailed evidence from Mr. Jevons, and we were saying, well, okay, where do you see this account? That there was some kind of salient split in the way that you were that Royal Mail was dealing with things, and what was going on in its business. And if you go over the page, you don't need to read all of it, but go over the page to line 17 on 292. So he referred to this section 17. Okay, so you're not going to find that in this specific section of the witness statement. And we go on and we do some more dances around this in the remainder of the cross-examination.
So I'm sorry, could you read the remainder of that
Yes,
answer?
you have to take a step back and you have to understand the broader economics of the business. But the point here is, this is Mr. Earwicker interpolating what the broader economics of the business are, because he doesn't have that material from Mr. Jevons. If you want an extract from Mr. Jevons' statement, you can go back to tab 8 in this bundle, where there's a section, I think the section that Mr. Lask was referring to, on cash balances and working capital, section 17. And you will not find in there any indication of the basis for a binary split which is being put forward. Now, in those circumstances, you don't have that factual basis for the expert to pontificate on these issues. And yes, the expert talked about using debt for financing acquisitions. Actually, that isn't what the tribunal refers to at all. And as a matter of principle, the use to which you put debt is not instructive. There are a whole range of ways you might deploy debt. The question is, when you're assessing for the purposes of interest by way of damages, do you hold debt? Are you making short-term investments? Yes, they were making debt. On the basis there was a putative overcharge, they would have needed to take on less debt, whether it was funding overseas acquisitions or doing something else in the UK, or dealing with problems that they had in the business from time to time. That's the key issue. And so, yes, there was a vast amount of agreement in relation to an awful lot of the data. The experts could get a long way down the road, and then Mr. Earwicker, without a factual basis, says, I can identify this split, looking at the broader economics of the way that Royal Mail works, even though the CFO doesn't support that distinction. And then says, oh, and look, if I do this analysis of where the debt was going, I can see it's going to finance particular acquisitions. Okay, fine. That may well be right. And as Mr. Lask showed in relation to Table 4, there isn't a disagreement about those sorts of things. The question is, what does that mean? Do you have to work out where the debt's going for these purposes? And did the tribunal rely on that? And the answer is no, it didn't. So it's not relevant, and it didn't. And that's why we say you don't have a proper factual basis for this. And so when the tribunal in the end comes through at 822, criticising the weighted basis that Mr. Delamere adopted, it does actually say, it recognises that these issues weren't addressed in Royal Mail's factual evidence. It wasn't blunt and oversimplistic. It was the best that Mr. Delamere could do. He put forward a 50-50 split, and he put forward a weighted split. And of course, the weighted split will then capture year by year whether or not you have more debt or more short-term investment. So if you have a year where you've got zero debt, all of the measure will be by reference to short-term investments. It's a simple way using the Table 6 information. But it's not oversimplistic, it's much more sophisticated than a binary approach, which is unjustified here. And then the final conclusion of the tribunal, which says, well, you're a net investor in the first period, you're a net debtor in the second. Well, as I explained, in corporate finance terms, you're both at any point where you hold investments and debt. So this is a case where it was within the gift of Royal Mail to talk about what it was doing. Its factual evidence didn't support the bold approach adopted by its expert. The expert can't make assertions of fact. Those facts weren't there. And instead, what the tribunal ends up doing is adopting this net investor-debtor approach, which neither expert refers to in their reports, and essentially wields the broad axe against DAF in favour of Royal Mail in circumstances where that was not justified. And in answer to the Chancellor's first question, it's about 3.5 million.
Right.
So in those circumstances, we maintain the position in relation to ground 4, and the exegesis on the expert material, which didn't deal with crucial parts of the cross-examination, does not assist Royal Mail in that regard. With that, I'm going to go head backwards, unless the tribunal the court has further questions in relation to ground 4 issues. I will go backwards to ground 1, 2 and 3 and deal with reply issues on those. Sorry. I'm probably going to be, I estimate about half an hour, unless the tribunal has questions. I don't know whether you want me to start now and just run through, or whether or not we pause just for the transcript.
Well, maybe if you are going to be about half an hour, I mean, when you get to 32 minutes, we're not going to sort of close you down, but then on the basis that you're going to be sort of half to 3/4 of an hour,
Yeah,
maybe it's a good idea to break.
that's what
Have a 5-minute break now.
right.
All right.
Maybe she's in. I mean, you've done so well so far. And then he lets us down at the last minute. Sorry, you're here. Just keep going.
For eyes.
I'll try and move through things relatively speedily. I know that there isn't a specific time constraint other than lunch, but let me start with ground one. I'm going to just deal with 4 points briefly. The nature of the error, why the error mattered in practice, why Merrick's in the Supreme Court is very far from the sort of magic answer that Mr. Ward suggested it was, and why the principle of effectiveness doesn't change any of this. So, starting with the nature of the error, the issue is very clear. The question is whether the tribunal approached the issues in the correct manner in moving from findings of causation based on inferences from the decision, which we find at 477, paragraph 477 in the decision. Might just be worth turning that up. It's at page 333. You'll be familiar with this section now.
Yeah.
Where it moves from that finding in relation to causation, which is concluded at 478, directly then to having reached that conclusion, we then place a value on the overcharge. In doing so, we adopt the broad axe approach. We say that in that progression, the tribunal failed to ask itself the proper question that, as I said right at the outset, McGregor on damages clearly articulates, has the claimant proved the amount of quantum? So just for your notes, the McGregor reference is 52.001, and for your notes, that's Authorities Bundle 4, tab 36, page 1785. Now, as I've said, we accept that the broad axe is an evidential tool, but it doesn't substitute for showing that there is a substantial loss, and showing that that substantial loss was more likely than not. It doesn't change the basic adversarial process. And by talking about doing quantum using the broad axe, as the tribunal does, with no reference to any requirement of proof, the tribunal is essentially moving to some sort of inquisitorial balancing exercise, and we say that is wrong. The evidence of substantial loss here was based on the econometric evidence proffered by the claimant in the form of Mr. Harvey's various reports. And just to be clear in relation to point highlighted by my Lord the Chancellor yesterday, our point here is not that the tribunal rejected the evidence of Mr. Harvey when adopting the Broad Acts approach. Far from it. It's clear at various points in its conclusion that it did use it. Our point is it was wrong to do so as it did, because that evidence had failed to make out a substantial loss, and having failed to make that out, it wasn't then open to the tribunal to say, well, never mind, we'll count on it a bit. And this takes me to my second point, how the error here specifically affected the outcome. Now, Mr. Ward referred to the tribunal having talked about, as he put it, the so-called identification issue. But I think it's important to be clear. If Mr. Harvey's econometric evidence was inadequate to identify a substantial infringement effect, there was no proof of substantial loss. Identification was critical to showing substantial loss. That's why there's a problem here as a matter of law, not just as a matter of fact. What we say is that because the tribunal didn't ask itself whether the claimants had proved the amount of the loss, they ended up using Mr. Harvey's evidence when it wasn't probative. And just to be clear, of course, we're not talking about loss of a chance here, where the analysis can be very different. If we, I'll provide the reference, but I took you to it in opening. Paragraph 329 of the judgment at page 283 describes how a regression model works. It's an equation, a complicated equation, but it's used to estimate the relationship between two variables. The essential purpose of this is to produce an estimate of the effect of an infringement. In other words, to identify that effect. And I think I also picked up what's referred to in paragraph 322 as 332, I'm so sorry, I'm correct, Mr. Burke, 332, about what's called the multicollinearity problem. And the tribunal did recognise that was particularly problematic here. But essentially what it did was it recognised there could be a problem. It later, as I'll show, and I've already indicated, recognised there was a very serious multicollinearity problem, a fatal multicollinearity problem to Mr. Harvey's identifying an infringement effect, but it was then willing to overlook that and give it some kind of credit. If the regression fails, it doesn't prove its outcome, the loss, and that is what happened here. And we can see that in relation to the two key aspects that drive the overall quantum figures that Mr. Harvey sought to evidence. And we obviously have those two sections that we've been to, but I would like to just go back to them very briefly, if I may. The foreign exchange issue, which starts at paragraph 373 in the judgment, page 299. And the key question here is whether the claimant could show that there was a substantial loss caused by a cartel effect apart from an exchange rate effect. And if it couldn't, then really that would not show substantial loss. And your lordship, I took you through parts of this section, particularly focusing on Mr. Harvey's evidence, because it's Mr. Harvey's evidence, whether he's made out the case that's important. And then we get to the conclusions, page 310, paragraph 407. And you see what's going on here. There was voluminous evidence and empirical testing of each of the experts' theories and approach. So here you see the tribunal saying, we're looking at both experts. It's not directing its mind to the question, has the claimant made out its case here? And it says it really comes down to the best method of capturing what was actually going on, consistent with the way that DAF operated its business, etc. The best method. No, this is an adversarial process where it was for the claimant to show that there was substantial loss. Now, it is right that we put forward from our expert essentially two types of evidence. One was criticising Mr. Harvey and explaining why his approach was flawed. And the other was saying, and there are ways you can do this that are better. Now, what is effectively being said here is, because you put forward analysis that said there are ways you could do this that are better, and we're not convinced they are the best ways, we're essentially going to give some credit to Mr. Harvey. If Professor Nevin had not put forward any of that material and simply critiqued Mr. Harvey, then you would have had a situation where it was plain that the case was not made out on substantial loss. And that is a concern that's carried through. So when, my Lord, the Chancellor emphasised that the Tribunal in these conclusory paragraphs here, and at the end of the GFC section, and indeed at the end of the whole consideration of the overcharge, talks about this balancing exercise, yes, that's precisely what it is doing, and we're saying that's the wrong way of dealing with these issues. We say that's correct, that's the error that essentially infects 410. We don't say one approach is right and the other wrong. Instead, we're left with a feeling that the answer's more nuanced. But they aren't a general inquisitor. This is an adversarial process where proof, as per McGregor, was required. Not precise proof of a specific number. Yes, the Broad Acts could be used, but what has been done here by the Tribunal is it's taken that evidential tool and it has used that essentially as a substitute for asking itself the right question. And it's for that reason we say that there is something missing as a matter of law in the Tribunal's approach. If we go over the page then from 410 to the start of the global financial crisis issues, we see here, as I explained in opening, the same issue arising. Mr. Harvey, having not declared that he'd actually had an initial intuition that you just use standard demand controls, had imported these dummies that radically affected the way in which the global financial crisis would be interpreted. As it's put at 416, they had the effect of taking those years out of account. And you have Mr. Harvey's approach, and you have consideration of the evidence that was put forward, and you have references to Professor Nevin's approach as well. But just to pick up two paragraphs in all of this, at 427, so this is before any consideration of any factual material, the fact that there are concerns with Mr. Harvey's GFC dummy variables doesn't rule out the possibility that standard demand controls might be unreliable. Now, the logic here is we've got serious concerns about Mr. Harvey's approach, but we can't be absolutely sure that an alternative using standard demand controls will be completely reliable here. It's a possibility it might not be. I'm sorry, just let me finish the submission and I'll come on. The fact that there are concerns with Mr. Harvey's GFC dummy variables does not rule out the possibility that the standard demand controls might be unreliable in capturing the abnormal effects of the GFC. So we're starting here with an approach that says we have concerns about Mr. Harvey and there are possibilities of concerns about using standard demand controls. And then it said if there's validity in Mr. Harvey's contention that some kind of paradigm shift occurred, then it could be appropriate to adopt measures which reflect the special status of demand effects. But the point here is, what's being said is we have concerns. There's a possibility that the other mechanism might not work completely to come out with some sort of perfect answer. But again, that's focusing on the alternative. And if Mr. Harvey's concern has Harvey's approach does reveal that there is some kinds of concern, it could be appropriate to adopt measures which reflect the special status of the demand effect. But that's not saying that Mr. Harvey's approach of using these dummies is the right way of dealing with these things. And that's what we then see, because you've got the consideration of the evidence, some of which Mr. Ward took you to, and then we come through to the conclusory sections in 435 at page 319. From the above evidence, it's not unreasonable to infer that this might, so the GFC might have triggered a major shift in the considerations that affected DAF's conduct. DAF said that the evidence doesn't indicate GFC had an impact above and beyond demand. However, we do think there's some justification for Mr. Harvey's view that GFC had a somewhat unique effect on pricing that might not be captured by the standard demand variables. So none of this is saying Mr. Harvey's approach is acceptable. It is saying it might be a concern in relation to the standard demand variable, the demand controls mechanism. And we see that carried through further in 439 in the conclusion. In summary, we have concerns about Mr. Harvey's approach to the GFC problem, but understand why he's done that and don't wholly reject it. And I go back to the point I made about the foreign exchange issue. Mr. Harvey's approach was being found to be profoundly flawed. It did not prove, on the basis of this analysis, that there was some sort of substantial loss. Nonetheless, the tribunal is saying, well, we'll give it some credit. And we say, again, in doing that, you're not asking yourself the right question. Did the claimant, through Mr. Harvey, prove that there was a substantial loss using this mechanism?
Was the tribunal entitled to infer that after a decade and a half of a cartel, where there was some contemporaneous documentary evidence in email form suggesting that the defendant considered it was benefiting from the cartel, not entitled to take the view that there was some material loss, such that your client's expert, who persisted in an analysis that there was zero overcharge, lacked credibility?
Well, let's take it in stages. First of all, the tribunal did take into account the role of the decision and that material and made the causation findings that I set out in 477, 478. It then embarked on the exercise saying, well,
that depends on whether you're right or wrong about your analysis, that they're not dealing with the issue of whether or not there's a substantial loss. And they may not have used those words in 477, but they certainly, as Mr. Ward pointed out yesterday, used those words or something very like them elsewhere in their judgment. And the point that my lord's making to you is that given the nature of the cartel, and given the fact that you gave no evidence whatsoever to explain what your clients were up to and why they were doing it, the tribunal was entitled to infer that, given that you did this with great the risk of an enormous fine at the end of the day, which you received, the tribunal inferred that this cartel had successfully led to the victims of it suffering substantial loss.
Well, let's just take that in stages.
Material, I forget how they put it.
It says material loss. That is in fact in 477 itself, which I took you to.
The paragraph my lord had in mind was paragraph 38, where substantial
38,
benefits.
that's right, you showed us yesterday. Anyway, Mr. Baird, we've got your point. We're simply making the point to you that since you can criticise Mr. Harvey or the tribunal's approach to Mr. Harvey, we follow that the tribunal decided this particular issue on two bases, one of which was saying, well, Mr. Harvey is to be given some credence, we find, on a balance of probabilities, which is how they start 477, but also they say from the fact that the cartel persisted for 14 years.
No, we say the fact of the cartel persisting for 14 years obviously is a fact that goes to the making out the causation point. We entirely accept that. The fact that the cartel continued for 14 years does not show you that there was a substantial loss caused. that does not take you there, and that is why there was such extensive
Just
econometrics.
why not substantial? Why isn't it an inference to be drawn that a rational company, properly advised, commercially sophisticated, would not conclude that it was earning substantially? You can argue about what that means, but more than de minimis, something which was worth taking the risk. Why isn't that a strong inference that the tribunal was bound to draw after such a prolonged period of time?
No, because you can't just assume that those risks were being taken for benefits. There are all sorts of circumstances where information can be shared between cartellists.
We know what, so, I mean, everybody knows, you know, exchange of information of this sort of data is now pretty much blacklisted. There's not much doubt about the legality of the sort of information that
Well,
being
I
exchanged.
think that the court needs to be extremely cautious about this, because you're talking about gross list price, not net pricing here. Yes, it is
It's
wrong.
cost, I mean,
Yeah, I'm not,
like 30,
look,
40 years.
I'm
for
not
courts
going
to
back
review
on the
this.
fact that this was accepted as an object case. But as we all know, object cases, although they are within the object box for a reason, cannot just be turned into effects cases. And that is what using a strong presumption, as the court is talking about, is effectively doing. You are effectively turning an object case into a presumption of a substantial effects case. There can be a whole range of reasons why companies do things that they shouldn't be doing. It may well be.
It wasn't part of your defence at trial that there was a cartel, but it was done for innocuous reasons, was it?
We said that the reasons, what we said at trial was that there isn't evidence in relation to the reasons it was undertaken. We did provide a good deal of evidence in relation to pricing matters from people both in the UK and in relation to.
The tribunal found, Mr. Ward showed us this passage yesterday, at paragraph 116. Therefore, in our view, the failure to call evidence. This means that if DAF wished to argue that because of the way it used the confidential information obtained through the cartel, there was no effect on prices, it would have had to adduce factual evidence to such
Yes,
effect.
I'm not
In other
disputing
words,
that.
what it's saying is really the same thing as it says at 38. DAF must have expected that it was going to have the participation in the cartel was going to have beneficial.
I'm not
beneficial
trying to
effect on
take
profit.
issue with any of that. I
Well,
am not.
It seems to me that, as I said to you in your opening, we're seeking to see how many angels can dance on the head
Well,
of a pin.
I think that is, with respect, that is not correct. What we are asking ourselves is, how is the compensatory principle to be met here? And here we say that they must still quantify. That
Well, if
those
you're wrong in saying that there's a gap, and you've told us now that you say there's a gap in the reasoning, but if you're wrong about that, then none of this gets you anywhere.
well,
We've got your submissions on why there's a gap in the reasoning.
I understand, my lord, but that is the legal point that we raise in relation to ground one, how it is that one should go about, even when you are dealing with a situation of a settled infringement. Breach of statutory duty has to be made out, there has to be gist of damage. That may well be something that can be presumed in relation to these issues, but that does not solve your quantification issue. That's the issue.
Just flex your example. Let's assume damages between 0 and 10, and that the tribunal comes to a conclusion, an inference, that it's because the cartel was egregious and very, hypothetically egregious long term,
Yeah.
and it's going to start by saying, well, I'm going to put a bit of broad brush, we'll start at 1.5 or 2. And that's my starting point. So it's between 1.5% and 10%. And then it says, all right, the regression analysis is full of unprovable or variable assumptions that we can't realistically get a handle on.
Yeah.
But we've got, on expert matters, on premium, we prefer Mr. X, on currency, we prefer Mr. Y, on GFC, we think it's evens. So we're not going to go with the highest figures that the claimants put forward. We're going to actually reduce it by about half. And that's more or less a parallel of what happened here.
No, let me take it in a couple of steps. Well, you may be right in the description of what's happened here. Let me just articulate what's wrong.
483 and 484.
Yeah, let me just articulate what is wrong with that approach.
Yeah, okay.
let's park the issue as to whether or not you could presume up to 1.5% because we've canvassed that issue. The question then arises whether or not the burden of proof has been discharged in relation to substantial loss. It depends on what evidence is then proffered, obviously, as to how the court or tribunal goes about analysing these things. If in relation to omissions, it is said, well, actually, we think the case is made out in relation to omissions.
So they said we're much more with Mr Harvey, 483,
Well,
on omissions.
Well, it's not just much more. That Mr Harvey has proved that there is a significant, he has identified an effect in relation to the communications here, and because there can be arguments about why that correlation arises in that we don't accept the defendant's approach to why that correlation arose.
There is an evaluative exercise.
So there is always going to be an evaluative exercise in relation to regression analysis because they're correlation analysis, not causation analysis. But if you don't have the correlation, the causation story doesn't, you can't make it out on the basis of the regression analysis. So taking your omissions example, if Mr Harvey had made out his case that he has proved that there is a correlation issue between emissions standards changes and pricing, and the story on causation as to why those occurred, the claimant's case is accepted. Yes, of course, in those circumstances, the tribunal can say yes. We would add that because that is the way the evidence is being put forward. If, on the other hand, in relation to the financial crisis or foreign exchange, it said, well, actually, Mr Harvey comes forward saying, well, actually, that's another 6% or whatever that goes towards his overall 10%. And it's shown that actually he hasn't proved that 6%. At that point, no, the tribunal can't just say, oh, well, I'll give it an extra 1 for that.
They don't really say that. They, on exchange rates, they say Mr Neville's position has more merit. They don't say 10% for more merit or 20%. And then on PFC, they say more evenly split, so let's call it 50-50. So they've taken 3 big clumps of variables.
Yes, I agree.
They've formed an evaluative exercise. And then they've got to apply it to the high point of Mr Harvey's analysis, which is
I understand.
quite high. And they've chunked it down very substantially.
All of this is absolutely accurate in relation to the conclusion. And what we're saying is, what the tribunal needed to have done in relation to those bits where it says, well, we think Professor Nevin's approach in foreign exchange is the better of them, but actually we're not going to completely go with him in relation to that, and we're going to give Mr Harvey some value in relation to it. We say that is not permissible because Mr Harvey has not identified, using the analysis that he has put forward, he has not identified a cartel effect in relation to the regression that considered the foreign exchange issues. There's no identification there. And so what we're saying is that where you don't prove on the evidence you put forward that there is some sort of identification of a cartel effect, then you don't get some kind of small credit for it. And that's where this tribunal has gone wrong. So if it had said, yeah, we think on emissions it should be, I don't know, 1 or 2%, because we've looked at the econometric evidence, Mr Harvey's made out his case and the case on causation's made out, then we accept that that would be the appropriate way forward. But what you can't do is when you've assessed the evidence and recognise the evidence doesn't prove the substantial loss on the basis it's put forward, you can't then say, oh, I'll give it a bit of credit anyway. Because the nature of the evidence being put forward, the basis on which it's being proffered, doesn't meet the standard for proving any sort of amount of loss.
Analysis is binary in relation to each of these, either proven or not proven.
Yes.
As opposed to, we think there's something in it, not quite as much as Mr Harvey proposes. We think there is something in it. We see the force of Mr Nevin's criticisms, but that doesn't mean to say we come to a 0 on that particular point. Their evaluation is it's somewhere between, and they can't say where.
Yeah.
Their evaluation is there is loss, but they can't quite put a figure on it.
I understand that that's what the tribunal has done, because that's what they're saying is
You
the
say that's
appropriate.
wrong in principle.
We say that is wrong because where you have put forward evidence saying, I have identified an effect by reference to the cartel, aside from an exchange rate, and can show that, and actually the analysis of the evidence says you can't show that. If you can't show,
You've inserted an analysis of the evidence. That's not their view. Their view is there is some evidence, it is informative. They can't put their finger on the graph and say where, but they're reasonably confident it's up a bit.
But that's why the nature of the evidence is important. Regression analyses were put forward. If they fail, if they fail because they have an identification problem, you can't say, oh, well, they kind of work. That's not how this evidence works. And that's why it is so important that there was a situation where the tribunal directed its mind to whether or not the way in which the claimant had put its case forward using this econometric material actually crossed the particular thresholds. Just briefly, if I may, I'll pick up the Merrick's Supreme Court judgment because with respect, none of the discussion we've just been having is affected by this. It's in Authorities Bundle Volume 4, tab 24. Now, Mr. Ward said this was a complete answer to DAF's case. It is a groundbreaking judgment on collective proceedings, but actually on quantification of damages, we say actually what it's doing is restating the case law and indeed citing the case law to which I took the court in opening. One can pick it up. It's perhaps worth just bearing in mind that when I say it was a groundbreaking judgment, that context matters here. Because what was being said was you couldn't certify a claim, as you know, you couldn't certify a claim because the tribunal had said you can't properly quantify damages in relation to this large class. And what the judgment of the majority, Lord Briggs, is saying is no, the fact that there are difficulties in relation to quantification doesn't preclude certification. And one of the things that's, you see that starting at paragraph 45 on page 1415, what the issue is, and 47, upon which Mr. Ward placed weight, was that the fact of forensic difficulties do not preclude a claim, and we take no issue with that, we never have done, nor do we say that there's some undue degree of precision. It is worth noting at 47 that there are these citations from the very paragraphs I took you to in McGregor here. There is nothing in this judgment that is qualifying the analysis of the authors of McGregor on damages. And I take you back to the point I made about that none of this material, including the references to Chaplin and Higgs, including the references thereafter to Davis and Taylor and indeed Asda, that go on through to paragraph 52, which is where Mr. Ward took you to, suggests that the authors of McGregor have somehow lost track of what's going on in paragraph 52.001, where they say you need to prove the amount. Indeed, it is notable that Mr. Ward did stop at paragraph 52, and at 53, you'll note there Lord Briggs saying there's an unresolved question where there remains uncertainty which can't fully be fully resolved. Whether the benefit of the doubt should be given to the claimant or to the defendant, it's unnecessary to deal with it on this appeal, and the court did not seek or have the parties' submissions on it. But it's clear from the above citations that justice requires damages to be quantified for the twin reasons of vindicating the claimant's rights and exacting appropriate payment by the defendant to reflect the wrong done. In the present context, that second reason fortified by the perception that anti-competitive conduct may never be effectively restrained if wrongdoers can't be brought to book. We have no issue with that, but that is identifying precisely the sort of issue that we say arises here, which is where there could be uncertainty, how do you deal with where the benefit of the doubt lies, where the burden of proof lies in relation to these issues. Now, actually what has to be proved, nothing in this judgment is suggesting that you move straight from a finding that there is an infringement and there is causation because the gist of damage is made out, monetary damage in the language of Professor Stapleton, to saying, well, then we engage in an inquisitorial approach, effectively just balancing up these issues. You still have an obligation under this adversarial procedure for the claimant to make out its case, and nothing there affects it. And of course, I do note, but obviously it's the minority, the dissent here, or it's not formally dissent actually, because of the only 4-member tribunal that gave the judgment in the end, but the differing views that are put in relation to these issues by Lord Sales and Legates in relation to these matters, where an emphasis particularly in the later paragraphs is on having a reasonable degree of accuracy in relation to issues of quantification. So, as I say, we've set out what the key issue is, we've explained where we say the tribunal has gone wrong. We think this is a matter of some importance in relation not only to this case, but how damages are dealt with more generally, because there is a grave danger that what you are ending up with is a situation where ambitious but deeply flawed econometric evidence or expert evidence is being given credence when it should not be given credence. And going back to a point that my Lord Justice Newey raised yesterday about Mr. Harvey providing the upper limit. Of course, in theory, what an expert puts forward is the upper limit for any consideration within the scope of a case. But one of the problems you have here is, of course, the upper limit of Mr. Harvey's calculation is based on him identifying the cartel effect using his methodology to come up with that blended 10%. And of course, what I've shown is that the tribunal didn't have a good basis to show that on balance he had made that out. And therefore, it does actually go both to whether or not a case is made out at all, but also the upper limit, which is one of the issues we raise in relation to ground one. Although my Lord Justice Green yesterday talked about the tribunal not simply splitting the difference, that is what it has done, and it has used that as the upper limit, notwithstanding the lack of justification for that upper limit. And as to the principle of effectiveness that it is referred to here, there is nothing in that principle that precludes a requirement that there is a need for proof of the quantum of loss. Proving causation is one thing, proving the level of loss is another. You don't have to have it as precise pounds, shilling and pence. There is no issue of effectiveness or disproportionality or any other concept of fairness being impinged upon. Indeed, there is a grave danger in terms of the references to effectiveness of slipping into the fallacy that where you're dealing particularly with follow-on claims, but this will also arise in relation to standalone claims, my lords, a grave danger of slipping into the fallacy of thinking that effective regimes in relation to competition cases give claimants money. That is not true. Effective regimes enable claimants with good claims for substantial loss to prove them. That is all we say is needed, but that's not what the tribunal has done here. I'm going to move on to ground two, if I may. I'm sorry I'm taking slightly longer than anticipated. 3 points. I want to deal with what Mr. Ward said about the tribunal's unanimous legal analysis in the judgment, paragraphs 176 to 230, and explain why his criticism of our position is wrong. Secondly, Mr. Ward has suggested that the absence of claims by indirect purchasers is relevant to the assessment of pass-on. With respect, that's also wrong. And thirdly, I want very briefly to pick up his point about the permission to appeal judgment that he raised. So just on the unanimous legal analysis, with respect, there isn't any issue here. So if we go to it, page 245 in the judgment, at paragraph 228 in particular, yes, that is the right reference, 245, paragraph 288. We don't have any issue with the idea that when you're talking about pass-on, the test for legal causation is that the burden lies on the defendant to prove a direct and proximate causative relationship. After all, that is what the Supreme Court has said very clearly in but you have our submissions based on both British Westinghouse and Sainsbury's, that test will easily be met if an input cost has in fact been the consideration, has in fact been considered in the structure whereby a company is able to recover those input costs through higher prices, and in particular, in this case, where you have a regulatory scheme which specifically takes into account those costs. So what we're saying is that in relation to one of the Supreme Court Category 4 cases, that test will be very easily satisfied. Mr. Ward on occasions tried to say, oh, well, the test must be the same for Category 3 and Category 4. I hope in opening I explained why that is not the case and why there is a salient difference between what may need to be proved in relation to Category 3 and Category 4. And of course, that was something that Mr. Ridyard also explained. When we work through the remainder of 228, we recognise that it's not enough just to assert that businesses want to recover their costs. That's obviously not what we've done here, but that doesn't mean that it's a high hurdle in relation to a Category 4 input costs case. And then there must be something more specific than that. And there are a number of potentially relevant factors that can be relied on. Now, of course, those factors were developed in the context of Category 3 cases, and that is particularly important. We do struggle a little with the knowledge consideration, but that is not of particular importance here. We say that when you're talking about input costs, we think relative size is not a relevant or important consideration. The relationship or association between what the overcharge is incurred and the products whose prices have been increased, or where you've got this regulatory structure, which we've explained, of course, that is then being made out. And then whether there are identifiable claims or identifiable purchasers, well, that might make the exercise easier. But as I say, you cannot have a situation where the absence of that is held against you in relation to a legal causation analysis. That cannot possibly be correct. It is not consistent with the approach in British Westinghouse. And although Mr. Ward drifted towards saying that British Westinghouse was in fact a policy-driven decision that was about allocation of damage down a value chain, that is simply not correct. It is obvious and clear from British Westinghouse and all of the subsequent case law that what those cases are concerned with is ensuring there is proper compensation, not overcompensation, not undercompensation. And therefore, there is a concern in relation to that, but none of this matters. There is a concern in relation to Mr. Ward's approach, but there's no criticism of the tribunal identifying that as a factor that would make identifying pass on easier, because if you've identified those people further down, that will be made out. So the point here is that in relation to paragraph 228 and the unanimous judgment, we don't have issues with that approach in relation to legal causation. Our problem is then with how it is implemented by the majority when we come on to paragraphs 573 and 574, which are on page 361. Because what you see in 573 first sentence is, having in 572 referred to those four factors, in the circumstances we do not think DAF can satisfy the legal test. So they're treating them as the definitive solution to legal causation. That is plainly wrong. It's not what Mr. Ridyard did. Mr. Ridyard's approach was right. And actually, it's going further than the tribunal's own summary in paragraph 228 that I just referred you to. This is actually a very straightforward issue in relation to legal causation. It really is a no-brainer. Mr. Ward was careful not to go to any details of the MIF umbrella judgment. That's bundle A4, tab 26, page 1510, particularly at paragraph 52. which makes that similar point. So we say there is a salient legal error here, and that salient legal error then colours very clearly the way in which the tribunal approaches all of the evidence it then considers. Because it goes on at 573 to say, while the four factors are not in themselves decisive or necessary, we think that in a situation where none are present, the evidence of factual causation needs to be that much stronger so that requisite proximity can be established. Now, it's one thing to say, if you've got these indications, it will be easy. It's another thing to say, well, where they're absent, we're actually going to push the parameters upwards. That is not justified. That is legally wrong. And we see that cashed out in 574. We'll still examine the evidence and the experts' opinions to see if it's strong enough to overcome the absence of the relevant factors we've identified. Wrong approach. Despite Mr. Bazant's careful, meticulous and professional approach to the material, we're clear that his evidence doesn't sufficiently bridge the gap between the overcharge and the downstream prices so as to establish on the facts the requisite proximity to satisfy the legal test for causation. But of course, in then assessing all of the relevant evidence, they've essentially expanded that gap in the way that they've approached these matters. And we don't then have to look through this section and say, well, assessment X would have been different or assessment Y would have been different. All of the consideration by the majority is coloured by that because they have set this much wider gap. And I won't repeat what I went through yesterday, but I did note that Mr. Ward didn't refer to, for instance, the references we provided to PC3, judgment paragraph 612, page 370, which is just a very clear-cut example of the majority relying on a factor that simply doesn't go to the relevant question and is indicative of these wrong approaches. But we don't have to identify those footprints in order for the approach to have been wrong. So we say that clearly that has affected and must affect the perspective through which all of the evidence is then assessed. As I say, Mr. Ward's points about the relevance of downstream claims are not made out. He suggested that the rules about pass on are about compensation allocation down the value chain. That's not correct. He also suggested the principle of effectiveness applies because the consequence of DAF's pass on arguments would have been to defeat the actual claims before the court by relying on non-existent downstream claims. Well, we're dealing here, we're not trying to avoid the principle of effectiveness, but the principle of effectiveness is in relation to compensation. Mr. Ward's submission here is no more than we'd like to be overcompensated. In those circumstances, his approach to the policy behind British Westinghouse and indeed Sainsbury's is not sound. It is of course correct that the compensatory principle requires account to be taken of pass on. That's set out in Sainsbury's Authorities Bundle 4, tab 23, 1384 of paragraph 197. But that does not mean that somehow the existence or otherwise, or the likelihood or otherwise of indirect purchaser claims in any way affects that compensation principle. Nor does it...
If the case is otherwise made out, there has been a pass on.
Yeah.
The fact that there may or may not be indirect purchasers who are able to make a claim must be neither here nor there.
Well, that's exactly our submission. Mr. Ward was trying to suggest that actually the policy behind this was about allocations down the chain.
Well, clearly the policy behind British Westinghouse isn't allocation.
Well,
that's not a... No. It's a very different sort of case. It's
absolutely.
It's a contractual claim.
Yeah. No. So I'm just dealing with...
No, I understand the point.
Yeah. I won't press it.
You need to press it.
No, I'm not. I got the clear message in relation to that. One last point, if I may. I'm just picking up on the permission to appeal judgment, whereby Mr. Ward seemed to say, well, look, what was really going on here was both the majority and Mr. Ridyard were doing the same thing, and he referred to the permission to appeal judgment, paragraph 11. I'll just quote it. Furthermore, the majority was testing, as was the minority, whether the claimant's prices would have been lower in the counterfactual without the overcharge. Well, Of course, that's absolutely true. That is what both the majority and the minority were doing as the overall test. But as I set out in opening, and Mr. Ward really didn't deal with in his submissions, the point is that Mr. Ridyard says in effectively carrying out that test, what the majority are doing are following Mr. Harvey's approach.
No, Mr. Ridyard doesn't say that.
I'm
It says
sorry,
Mr.
I will deal
Harvey.
with Mr. Ridyard in a moment. What I am saying is that Mr. Ridyard says that Mr. Harvey follows the what changes approach,
You took us through this. in
and
the
that what the majority is doing is effectively applying that. Now, Mr. Ridyard, as Mr. Ward very properly says, doesn't specifically call out the majority as doing that, but it is plain that that is the way that the majority is dealing with these issues. And as Mr. Ridyard puts it at paragraph 723, it is a subtle distinction, but it is important.
Yeah, okay.
And so, not only do we say in relation to supply pass on that there was a legal error, a clear legal error, not affected by the error analysis, that then infected the whole approach of the majority, it also approached it on the basis of Mr. Harvey's question, which was the wrong way of dealing with these matters. I'll now move, if I may, just to ground 3. So this is the value of commerce and bodies issue. And the question for this court is whether it was open to the tribunal to interpret the commission decision in the way that it did, essentially. And we say it's very clear that the tribunal took the wrong legal approach to the decision. In very basic terms, the tribunal was required to consider the wording, context and object of the decision. Those are the basic building blocks of interpretation of European decisions. Indeed, they're actually basic building blocks of interpretation of most decisions. That is not what they did here. Now, Mr. Ward made a series of factual and evidentiary points about bodies yesterday, but ultimately that's beside the point. It comes down to a question of interpretation and legal interpretation, because going back a step, this is a question of liability. The burden lies with the claimant to show that there was liability in relation to the bodies within the scope of the tribunal, within the scope of the decision, and obviously not the way the tribunal approached this issue. It didn't engage with those basic principles of text, context and purpose. Now, Mr. Ward took you to the various recitals of the decision and advanced his interpretation based on that. Now, quite apart from the fact, and I'll come back to, his reading of these provisions wouldn't get him home, with all respect to Mr. Ward, he is not the tribunal. And the tribunal did not refer to a number of the key recitals upon which Mr. Ward refers. If we go to the decision itself.
Well, that may or may not matter, because if the tribunal's conclusion that the commission decision did cover bodies, it can be justified by reference to provisions in the decision which the tribunal didn't refer to. It's still correct in its conclusion, isn't it?
That's obviously right, my lord. If the legal interpretation of the decision is plainly correct, then in those circumstances,
I mean, what you've got to show is that the provisions in the decision which Mr. Ward relied upon, the recitals he relied upon, don't demonstrate what he said they
well,
demonstrate.
I'm not sure that's
It's a
quite.
matter of construction.
Well, I'm not sure that's quite right, because we haven't had a full argument on construction here, as I don't think that was it ever intended to be the case. What we have to take issue with is the approach of the tribunal in interpreting the decision, and the approach of the tribunal was obviously flawed because it didn't approach it on the basic principles of text, context and purpose. If we were going to have a full discussion about the construction of the decision, there might be further material that would potentially, or further submissions that would be made in relation to it. But in any event, I'll explain why the decision is clear.
Yeah, well, I think we should focus on the decision. rather
Yeah,
than-
well, that's where I'm going, my lord. So tab 4 in the bundle, in the supplementary bundle, I'm so sorry, tab 4.
Yeah.
sorry, I'm just finding one reference, if I may. Just bear with me. Yeah. So if we start with recital 5, which is on page 17. The products concerned are medium trucks, heavy trucks, both rigid as well as tractors. The case does not concern after sales, other services and warranties for trucks, the sale of used trucks, or any other goods or services sold by the addressees of this decision. Now, Mr. Ward professed profound shock at the reliance on the other goods not being included in the decision. I obviously have sympathy for his shock, but it is at paragraph 105 in our skeleton, which is at page 81 in the core bundle, where we emphasise.
Mr. Ward's shock. The issue is whether that wording is apt to cover truck bodies.
Of course, but bodies are obviously other goods apart from the rigid or tractor
They may or may
trucks.
not be. Depends. Doesn't it depend upon what the Commission was referring to when it says rigid trucks as well as tractor trucks?
Well, yes.
Was trucks without their bodies on, or trucks without their trailers on?
Yeah, there is a sort of profound irony about all of these submissions being made by Mr. Ward, because although it is quite correct that one doesn't interpret the Commission decision by reference to the interpretation of the CAT's own judgment, it is worth noting paragraph 55 of the judgment. Apologies, my file's just fallen to pieces for a moment. Paragraph 55 of the judgment. There are 3 series of DAF trucks, LFs, which are comprising the smallest lightings trucks, medium-sized CFs and the larger XFs. Within each series there are numerous models. During the period there were various LF45 and 55s which carried different weights, had different suspension, different engines and so on. As well as choosing a particular model, the customer may choose either a rigid truck with a fixed chassis to which a body is mounted, or a tractor truck used to tow a trailer. So, in fact, the language used by the CAT in its own decision is distinguished between rigid trucks, to which you can attach a body, or tractor trucks. So, the starting point is that actually rigid trucks, which are cab, chassis, suspension, etc., which are drivable units, and actually when you want to fit a body, they're just driven to the body makers. Those are.
If you talk about, I'll go back to my simple point about a 7.5 ton truck.
Yeah.
A 7.5 ton truck is a truck with a body on it.
Well,
because I don't know if there's any evidence. I suppose there is. I'm not asking you to give evidence, but I doubt very much whether the truck without its body on weighs anything like 7.5 tons. It probably weighs about 5.5.
No, it's not to do with the weight of the truck. It's what overall load the truck.
Right, same point.
Well,
whether it's
with
payload
respect,
or weight,
no.
it's the same point. The truck without its body on doesn't have any payload. You can't load anything in just the chassis of a truck.
No, my lord, that's obviously true. But just as you don't suggest, or no one would suggest, that there could possibly be an infringement in relation to the loads that are carried on a truck, the fact that a truck can carry up to a particular weight, including its body and a load, doesn't tell you with respect anything about the definition that you're dealing with. These are categories of truck defined by their total weight limits. That is what is being defined here. It has never been suggested that somehow the weight measure that's used here is indicative of the inclusion of a body at all. The weight limit is what the total is that you can put on the truck, and that includes the payload, whatever additional body weight you have as well. But if you start thinking about the idea that the weight of the truck is defined by reference to the body, the weight of bodies would vary enormously. That's not what you're talking about. And also, it would apply to trailers, because when it's talking about weight categories, it's also talking about the weight, the total weight that a tractor unit can pull And then you're talking about the total weight of the trailer and the payload that can be put on the trailer. Now, there is absolutely no reason whatsoever to suggest that those categories are including trailers or bodies or tail lifts or any of the other goods that can be attached to a rigid or a tractor truck respectively. So that's why we say, even just looking at recital 5, the position is clear. But let's also bear in mind here that what we're talking about in relation to this is what Mr. Ward has referred to, although it's not language actually used by the tribunal. It refers to Mr. Ward's submissions about factory fitted options. But Mr. Ward says, well, the bodies were fitted on Royal Mail trucks in the DAF factory, so they're factory fitted options. Now, as I took you to the evidence of Mr. Ashworth that was unchallenged, and as is referred to in the decision itself, there is a vast variety and complexity in relation to trucks. One can see this at recital 26. Trucks are not commodity products. There are a vast range of options in relation to a rigid truck or a tractor truck, leaving entirely aside bodies, tail lifts, trailers, whatever else. And when we talk about factory fitted options, there is a terrible solipsism in Mr. Ward's submission. He says, well, we got, as an exception, our bodies put on by DAF in its factory. Not manufactured by DAF, and I'll come back to that. We had them put on. But he doesn't suggest that these were general factory fitted options for all DAF's customers, let alone for any other customers, let alone for any other manufacturers. And he's right not to do so. Because as the evidence showed, this was an exceptional arrangement with a very large customer. The only other customer of DAF that got this was Morrison's. And in the circumstances, the idea that you treat bodies for those exceptional customers as amounting to factory fitted options, which no one else was being offered, is incoherent in relation to the reading of the decision. So there is a clear exposition of what factory fitted options are. It's all of the variety you can get in relation to particular trucks. You've got bodies which are provided, the claim is in relation to third-party manufactured bodies that are provided and fitted on Royal Mail trucks, and there's a discussion about where that occurs. Royal Mail actually, during the period, it was actually buying trucks from DAF and having bodies put on elsewhere. That doesn't mean that they're factory fitted options in any way. And as I've stressed, the decision repeatedly refers to manufacturers. Now, of course, up until 2007, it's accepted that DAF wasn't a manufacturer of bodies at all. And there's no evidence that other truck manufacturers were actually body manufacturers as well. So Mr. Wood is speculating that although the decision talks about manufacturers, it should cover DAF because it later in the process began manufacturing. But let's just think about what is he's actually alleging. He's alleging that in relation to bodies which are not manufactured, that falls within the scope, even though the decision is all about manufacturing. Now, there is no reason why you would interpret a decision which repeatedly refers to the truck manufacturers as covering third-party bodies in relation to the scope of infringement. Indeed, Mr. Ward's point goes against him in relation to the particular claim he makes. Because even if he were right, and he's not, he's talking about manufactured bodies being the subject of the infringement, not the bodies in relation to which he makes a claim and which the tribunal included within the value of commerce. So it's for these reasons, referring to these various parts of the decision and the overall structure, context and purpose of the decision, that it's absolutely clear that we are not talking about these bodies, third-party bodies, falling within the scope of the infringement. Now, as I say, one does do this by reference to the decision, but it is also instructive, of course, that when we go back to the tribunal's decision on these issues, of course, the tribunal said that there was a separate market for bodies and trailers with a whole range of other participants. Now again, it's just not coherent in competition law terms to be talking about an infringement covering the products made by those other parties who are not addressees of the decision, whether in the UK or elsewhere across Europe, and say, actually, this infringement decision covers their products as manufactured by them. And the findings of the CAT in relation to the market simply reinforce that. So there is no coherent basis for this reading whatsoever in relation to the decision. There's no mention of bodies, there's no mention of trailers, there's no mention of tail lifts, and that is because a rigid truck is something that has the potential to have a body put on it. A tractor truck is a unit that has the potential to have a trailer added to it. Bodies and trailers, they're not within the scope of the decision. And none of this depends on issues to do with external evidence at all. I am just doing this by reference to the reading of the decision. So Mr. Ward and indeed the tribunal are speculating about the terms of the decision, and of course the tribunal, as I've said, didn't approach the interpretation of this decision properly. All it says about the decision is, oh well, DAF could have clarified that bodies weren't involved. But the difficulty there is that, of course, taking it from a truck manufacturer's perspective, who doesn't manufacture bodies, or didn't in the past, and other manufacturers, they just don't think in those terms about these issues. And also, as I've explained, the idea that there's just a full liberal negotiation about the precise terms is not something that one can assume. So, in those circumstances, the paragraphs in the decision that seek to suggest that we have a situation where actually the decision covers third-party bodies manufactured, as I say, by third parties, but then supplied through DAF is just not tenable. And you do have Mr. Ashworth's evidence in paragraph 73 of his witness statement that explains we passed them through at cost, and on occasion we added a small amount in relation to the value of the body in relation to that. But that, I accept, is not germane to the interpretation of the decision. One thing I should pick up, however, is the point that was made by my Lord Justice Green, possibly about the issues concerning value of sales. Value of sales, it's extraordinarily important to be clear. Value of sales figures that are provided to the Commission do not give an indication of the scope of the infringement. And we know that because we actually have a statement to this effect in the Landkreis Nordheim case, which is in the bundle. I'll just give you the reference in relation to it.
I mean, my issue is really about non-disclosure in the CAT. We don't know what information was put by DAF to the Commission for the purpose of those paragraphs 5 and onwards, and the paragraphs in particular on value of sales. So we don't know whether or not DAF's own view, what its own view was of its product.
Well, let's just pause there.
It's not really...
There was a vast amount of material provided that was available, the documentary material. Yes, it's true the settlement and leniency statements by DAF and the other manufacturers weren't provided.
But let's assume, just to test the proposition, that had said, because the relevant paragraph in the decision refers to for the purpose of the infringement decision, for defining the infringement.
Yes.
So let's assume that it said, we exchange information on the following trucks without bodies and the following trucks with bodies and the following trucks where we were going to improve, there was an option for a body, and we exchanged all that information and potential gross prices on them. That would be relevant, wouldn't it?
Well, no, I'm not sure that is right, because it's what the Commission in the end decides is relevant in relation to it, because it might not.
It says in the decision that it relied upon statements made to it for the purpose of defining the infringement.
Okay, but
and my point is merely you're making a submission about what must have been the case. Well, we don't know, and the CAT didn't know.
Well, that's to be fair, it is very clear from the interpretation of the decision, and the submissions made in the course of an investigation by parties do not dictate
that. Then, of course, you're right. If it is that clear, then we
No,
can-
Clearly, if the decision is very clear that it doesn't include bodies, well, then that's the beginning and the end of it. But if it's not very clear, and it could be either way, then my lord's point has to be right, doesn't it? You've chosen, for whatever reason, never to disclose, amongst other things, your settlement discussions with the Commission, which would or would not prove this point
No,
to be right or wrong.
it doesn't. It doesn't do that because you can't tell what the Commission accepted from our submissions, submissions from other manufacturers and so on. It doesn't tell you the interpretation. With respect, that is not a correct analysis. And it's the same in relation to value of sales. In fact, we know that the Commission asked for value of
You
sales.
say it doesn't. We don't know that, and the CAT doesn't know that.
No, the
We
point
don't
I'm
see the
making-
correspondence of what happened with the Commission, so which you can then track into paragraph 28, or whatever it was. How does the CAT know? Which leaves us in the position of saying, is the decision ambiguous? If you're right, then you're right, period.
Yeah.
If it's ambiguous, we've got to ask ourselves no more than, was this a reasonable interpretation of the decision given the
Well, I've
circumstances?
explained why the reasoning of the CAT, even on its own, is not a reasonable
We understand
interpretation of the decision, even if it wasn't clear. So there are three layers of argument. But the point I'm making in relation to the third is that when you come to interpret a Commission infringement decision, the submissions of the parties don't tell you what the Commission actually decided. And therefore, you've got to be extremely cautious about that.
Might or might not.
No,
but it might have done.
Well,
We
let's be
can't just
let's be
assume.
clear that in relation to the value of sales, we actually know that the Commission asked for data that didn't include a whole range of trucks and equipment, some of which we know this from the Landkreis Nordheim case.
That's not this
No,
case.
but this
Yeah,
case, in
no,
this case,
Yeah, no, but it is this infringement decision. It's concerning Daimler, but it is precisely this infringement decision. That's the only reason I'm raising it, because it coincidentally, Daimler had an argument that says any sort of specialised trucks, they're not within the scope of the decision. And one of the things it relied upon was the fact that the value of sales demand made, the request for further information, said, don't provide us with data on specialised trucks. So Daimler turned around and said, well, specialised trucks then are not within the scope of the infringement decision. And the court turns around at paragraph 66 and says, no, you can't read anything into what is done in relation to value of sales data for the terms of the interpretation of the decision. Now, if you can't do it in relation to the Commission's own RFI and the information you provided with it, a fortiori, the fact that you're putting in submissions alongside all others doesn't improve the situation. In other words, it doesn't have evidential value. And just for your notes, that's Authorities Bundle 4, tab 34, 1732, paragraph 66 is the key paragraph. So, no, my lord, I am going further. But that's effectively a third argument rather than anything else. Just a couple of final points. Mr. Ward relied on the Preston-Petradell doctrine, which relates to presumptions being made in relation to witness evidence. Of course, that can't be used in relation to legal interpretation of a decision. I mean, it's irrelevant for those purposes. So that doesn't assist Mr. Ward at all. That goes to factual matters. We say it doesn't apply, but it certainly doesn't assist him in that regard. There was some suggestion that there'd been a change of position by DAF and that this mattered. That is not correct. The reference that was made that Mr. Ward referred to in the judgment of 468, that was, just to be clear, summarising Mr. Ward's own argument. And powerful though he is, that doesn't make it true. That was his allegation that we had changed.
what's 468 about?
That's what it is.
Because
Sorry.
on the face of it, it seems to be saying, as I've read it anyway, that DAF had changed its tune.
Yeah. Well, as I say, what it's actually doing is recording Mr. Ward's submissions in that regard.
No, I don't think it is with respect. I think it's actually the tribunals.
Mr. Ward's main point is that bodies are within the scope of the settlements. That's Mr. Ward's point, my lord.
What do you say about it? Until August 2021, sought to argue the infringement was limited to the naked truck.
Well, we said we disputed that.
Well, those words must have come from somewhere.
Well,
Where's this dealt with?
I'm sorry.
dealt with in one of the previous decisions.
I don't believe it's specifically dealt with, but the allegation was being made and we were saying, actually, we hadn't changed our position in relation to these matters. And the tribunal doesn't then rely on that in any event, but I'm just picking it up for completeness because Mr. Ward referred to it. And then the final point, I think, is one that I've already dealt with, which is the point in relation to the interpretation of the decision and the role of settlement here, where we say that you shouldn't assume that there is some sort of broad discussion.
Okay.
Unless I can assist the tribunal further, those are the submissions.
No, thank you very much indeed. Right. Well, thank you all very much indeed for your extremely helpful and illuminating submissions. We obviously now have to go away and think very carefully about it. We're not going to get a judgment this side of Christmas, you won't be surprised to hear. We will let you have a draft as soon as possible, but I'm not going to make any promises. When you receive the draft, please limit yourselves to typographical and similar corrections, not an invitation to re-argue points, and also please pay careful attention to the terms of the embargo on the front of the judgment, and ensuring that there's no inadvertent breach of that. I'm sure there would never be a deliberate breach of it, but the inadvertent breaches of the embargoes have become slightly frequent, and it's something the Master of Rolls likes us to remind everybody about. So apart from that, it only remains to wish you all a very happy Christmas and New Year, and I hope you'll get some sort of rest after what has been, albeit only 2.5 days. Obviously, a tremendous amount of work has gone into this case on all sides, which we recognise. Thank you.
Corais.